It works. Hello, everybody. Welcome. We are going to have quite the crowd today. I am just fascinated by the fascination with the property management forums. Hey, Mark. Hey, Ron. Whoa, definitely have a celebrity star-studded cast today. This is great. Thank you all for being here. I'm watching my clock. I'm not quite at 10 o'clock yet. So I'm going to give you another minute or so. I'm going to go ahead and pause. I think I'm probably even recording already. Yes, I am. So I'm going to go ahead and resume the recording, and we're going to go ahead and get started. Let's get through the sundry items. So first of all, we are at the Greater San Diego Association of Realtors, and there's my name and there's my telephone number. And while I would rather speak with you on the phone, email is a good backup. Sometimes it's something that, you can just send me an email and I'll answer you at 1 or 2 in the morning. And for those of you who know me know that that's frequently the case, that I will answer you at the oddest of hours, but it's easier than calling you at 1 or 2 in the morning. So if you're having trouble getting a hold of me by phone, then certainly please send me an email. I want to help you. I'm vested in your success. As I always say in my webinars, if you look good, you make me look good. So I really want you to look good. Okay. So it's kind of an important thing for me. I've been doing this long enough where, for me now it's all about others and not about myself, although Linda would not necessarily agree with me there. But anyway, so here we are, here we go. Here are some credentials, I guess, that make me qualified to speak about the subject matter today. And so I have been in real estate. I put a 40 here and then a plus sign. I'm approaching, am I hitting 50 yet? 50 years in real estate, getting there closely. So I just stopped, having to change it every year. And so I left that alone. I do teach continuing education for attorneys. So I do teach real property laws, MCLE credit, ABA approved course. And then I have, obviously down at the bottom, I have put in bold print property management because I taught property management at colleges for many years. And so I guess that makes me qualified, right? And the old story, folks, for those of you that are newer in this business, realize all this stuff on this page is nothing I ever intended to do. It just kind of accumulated as I went along. So for example, I've been a member at large at NAR now for many years, but I'm fairly vocal there and I do like being involved. But better yet, I like bringing it back to my realtor friends, my community, and making sure that you're all aware. So I was chair of risk management West at NAR. I was chair of realtor risk management for CAR, and so those are, I guess those are okay, but that's why all of my webinars all come from a position of being careful and making sure we're doing the right thing the first time. So we're going to be talking about stuff that's going to appear to be legal. I am not a practicing attorney. I have no interest. They work way harder than we do. I got to tell you that. And they don't make nearly as much money as people think they make. So that being said, I do a lot of trial work as an expert witness. And again, that is a title. So I'm a court certified expert witness. Remember, DRE has said you may not call yourself an expert. In fact, we just changed our website because we hadn't even noticed it until one of our agents noticed that we had real estate expert up there. And so we changed the word to professional. But I can use it if it's in a title, or if you are a certified distressed property, credential, whatever expert, then you can use it in a title, but you may not use it in an advertisement about yourself. And that's, again, that comes straight from the Department of Real Estate. And I love the Department of Real Estate. I mean, you want to keep them close, right? But you want to be paying attention to what they have to say. So let's go ahead. I'm gonna let's see. Standard of care is my specialty. So code of ethics, things like that. Agents' duties of inspection and disclosure, market conditions in San Diego County. Our conversation today clearly not intended to be a substitute for the advice of your broker. And we have some brokers here today. So, and again, for all of you, please, broker, salesperson, whatever, I am here to help. Certainly not a substitute for the advice of your attorney. Please consult with them as appropriate. You really need to be listening to your broker, folks, because your broker has the experience out there to help you, as well as the broker has to defend you. So we want to be nice to the broker. I always say we love our broker, take good care of our broker. Our webinars are intended to be interactive. Please utilize the Q&A button. Unfortunately, we have quite a few people very fortunately, we have quite a few people here today. And so if I open it up and make a hot mic, then we're going to have a whole bunch of people saying things at times that it just unmutes people for some weird reason. And we're still using this Zoom program. So I did a talk for the DRE a little while back, and they're using Microsoft Teams, and so it takes a little getting used to, especially if you've been using Zoom all this time. But anyway, so I do look forward to hearing from you. Please ask questions. It's important. We have a lot of material to cover today, but if I'm not getting any questions, I'm going to speed up. So that's just how I do things. So please ask questions. So today we're at 10 o'clock in the morning in beautiful San Diego, California. Residential property management forms. This afternoon from 2 to 3, I'll be talking about creating a DRE compliant template in Zip Forms. That is actually one of my favorite subjects. It's a lot of fun. Whoops, where'd the rest of my calendars go? Darn. Oh, no, that's not good, Mav. Okay, that's really not good, because we have, Wednesday, we're doing top 10 risk avoidance techniques. And then on Thursday, we're going to be doing changes to the residential purchase agreement. Believe it or not, there were a lot of changes that happened in December. They didn't get the fanfare that the major update that we did back in 21 had, but there were some significant changes, including asking the seller to pay for the buyer's broker's compensation. And I'll be talking about that on Thursday morning, and then Thursday afternoon, I'll be doing the buyer representation agreement. They just kind of go hand in hand. And I've been telling you this for at least 20 plus years, you need to be using that buyer representation agreement. And we have changed it from the buyer BRE. Now it is the BRBC. And I just kicked up a class to the Department of Real Estate for approval for DRE credit on it. It won't be here in time for Thursday's class, but you'll get, Thursday's going to be a busy day, and it's each of those sections is 2 hours. So a lot. So question number one, hi, Lena. Hey, Lena, thank you so much for your kindness, dropping by that at my office. Thank you so much for that. But no, actually I am remote. We are on a webinar. So thank you, Lena. Thank you very much. And I will circle back with you after this. Okay. So, because I do want to say thank you personally. So today we're going to talk about member benefits. We're going to talk about residential property management forms, not the commercial ones. Commercial is a whole nother class. But we're going to talk about the residential property management forms. And I want to talk about some key concepts. So it is residential. It is, there you go. I've repeated myself. So it is the residential form. Please check with your broker before you try or attempt to do property management, because remember that property management is not normally insured without a rider. So for example, in our office, we have a rider for property management. It's a separate insurance policy to cover the activities of a property manager. Okay. And so we're going to differentiate today between the leasing agent and the property manager. We're going to talk a little bit about that briefly, just to get that out of the way. And then we got forms to do. So make sure your broker allows you to do property management. So before you do property management, and again, when we're talking property management, I'm going to show you some of the little caveats in there, but you absolutely need to check with your broker. I have a case right now. It's not in California, but it's a case where one of the sales agents was actually managing properties for someone, and they were affiliated with the brokerage, but the brokerage doesn't allow property management, and they were doing property management. And again, sometimes the questions between what is property management and what is leasing agent will come up. And we're going to talk a little bit about that here in a second. Okay, so are you a leasing agent or are you a property manager? And what is the difference between the two? So a leasing agent once the keys or possession are handed over to the tenant lessee, and the new form, form for that talks about this. Once that happens, it's over. Once, if you are a leasing agent, and so most real estate agents will do leases, but property management is a whole separate entity. And I can tell you, we're going to see today how complicated it is and what all is involved in a transaction where you are a property manager. So, but just take it for educational purposes here. Once the tenant is in the property, once the tenant has signed the lease agreement, you are really done. All right. And so you do not answer calls about repairs. You do not do repairs. I see this all the time where the real estate agent, okay, listen, folks, we're helpful people, right? But they get in there and they start doing repairs on stuff. And it's like, that's not your job. You're not a contractor. And sometimes you just got to say no. Okay. You do not accept rent checks. I've been management at 3 of the largest brokerages in San Diego County, and it was a horror that we would have a tenant walk into the office and say, "Here's my rent." We would go, "We don't do property management." So accepting rents on behalf of the owner constitutes property management. And so, if you are a broker, you can open up your own property management division, even within the company's division. But you have to have permission of the broker that you are employed by if you are a broker associate. Okay, so most property managers, in my experience, do only property management. They'll do an occasional sale. And why? Well, in property management, it's good money, right? It just keeps coming. It's just, you're making nickels a month, but if you've got enough doors, as we call them, then you may actually make a pretty good living. And I have a very good friend, Rick Snyder, who is, I know he has over 450 doors in San Diego. And so, it's a living, right? I mean, that's quite a bit. But a leasing agent does not provide forms. And I'm going to tell you, I've had some real ugliness in this, where the agent puts the tenant in the property, backs off, goes away, says, I don't do property management, and then the tenant doesn't pay the rent to the owner, and now the agent is putting together the 3-day notice to pay or quit. You're doing property management, right? Or notice to cure or something like that. And when we get in, I'm going to show you the numbers of forms that are available to you on both sides, property management and a leasing agent. It's an amazing mountain of paperwork. And the defense I keep hearing is, well, I didn't charge for it or whatever. I'm sorry, you did it. So you don't have to be compensated to be considered to have worked in a agency capacity. So you do not provide forms, and that includes, once the keys are gone, you're gone, right? When the tenant moves out, the owner can call you up and say, I need you to find another tenant, but you cannot be involved in that. Again, check with your broker, please. Your broker is your responsible source and has that information for you. Okay, so but let's talk about casual property management. And so all those things that we just talked about a minute ago, all these 4 things are things that agents do that make them become casual property managers. And the Department of Real Estate says, okay, you said you're not a property manager, but then you were doing stuff that constitutes property management. So we're not going to call you a property manager. Okay, we agree, but we are going to say you're doing casual property management. And so if you're doing casual property management, of course, you're going to be, it doesn't matter. It's just a name. And so the Department of Real Estate is going to be pretty heavy-handed about that. Okay, and so I need to differentiate this. This class today is on the forms. I did another class on the practice of property management, actually live at the association, and it was, there weren't any seats left. I mean, it was just crazy, but I think I talked most everybody out of it. But I think property management's a good thing to do. I really do. I just think that you got to be aware of what you're doing, and definitely check with your broker. So here's some key concepts. Doing real estate related activities on behalf of another. No matter what it is, folks, whether you're a property manager or a leasing agent, whenever you act on behalf of another, you have to have a real estate license in California. Okay, so a lot of people think, well, now first of all, I have property, okay, and I am managing my own property. That is okay. All right, I don't need a real estate license to be able to do that. I can own property in Wyoming, which is one place I don't have a license, right? But I can own property there and do my own property management. But but I may not do property management for others in Wyoming. Does that make sense? And that's kind of just breaks it down into the kernels. All right. So, and if you are doing property management, I don't care what you call it. If it is anything on behalf of another, you must be operating under the supervision of a broker. Okay. So, and then again, there's a lot of in Linda's office, we have a lot of broker associates. They're brokers working under Linda, who is the broker for the company. So you must be operating under the supervision of a broker, and that broker is responsible for you. And you need to be keeping them aware of what you are doing. Okay. So remember that property management is the most investigated entity by the California Department of Real Estate. I mean, and one of the reasons behind that is because of the trust funds. And we'll talk about that in just a second. So the Department of Real Estate, if you go to their website, they have all kinds of literature all for the tenant, right? We are expected to be educated and know what it is that we should be doing and not doing, but they are there to protect the tenant, because it's usually the tenant who ends up in harm's way. And as you know, if you've done any of this type of thing, it was a very tenant-friendly environment in California. The current governor, instituted statewide rent controls. It's very tenant-friendly, and there's a lot of political reasons behind that. But there's the website landlordtenant.dre.ca.gov. That's the start of things. They publish a California Tenants Guidebook, which now I'm wishing I had pulled up the DRE's homepage, because there's a lot of really good information there. You just gotta go look for it. That's all. And then here's some more. They have a reference book. It's the REF 09 form, and that has more information about property management. Know your housing rights. So if you really want to do property management the right way, you will be surprised. There are volumes of things that are involved in there. I'm writing a class right now on fair housing and on implicit bias, and I can tell you the DRE is a great resource. They have a lot of good material in there, but you got to read it. Okay, so know your rights. So why property management? Why is it the single most investigated entity in real estate? And it's because of those trust funds. Normally, the trust funds are what gets us into trouble, and so we're looking for the money. I can tell you that right now there's about $6 million worth of trust fund money that is missing in the state of California, and the Department of Real Estate is looking to find it. So this is why a property management company tends to be the most investigated entity. Again, you have money in trust for others. Most brokerages on the sales side of things have eliminated trust accounts, broker escrow accounts, and opted instead for the money's going straight to the escrow company or whatever. We changed our contracts back in 2012 to address that issue, that we no longer take checks. So understand that trust funds create problems for the brokerage. You've got to have great accounting. I know that I do counsel with quite a few property managers in San Diego County, and I can tell you they all have software that handles all this. They have attorneys, they have CPAs, they have EAs who are doing this for, making sure that that these things are being done correctly. Okay, so let me just take a look here. I'm just wandering through my Virginia. You're in there twice. Okay, all right. CAR, by the way, has omitted the trust fund forms. They used to have a whole bunch of them in there, but they decided they were going to get rid of those. And they also got rid of the vacation rental agreements and stuff. And I'm kind of sad to see those go. Those still appear to be in the program, but I was on the committee that created the short-term occupancy agreement, which later became the vacation rental agreement. And so I think a lot of what's going on with those short-term rentals that has created a problem is that a lot of times the owners are not paying the TOTs, and the TOTs are the transit occupancy taxes. And so because they're not paying those, the real estate agent can end up being complicit in that. Plus, it'll start out as a short-term rental, which is defined as less than 30 days, so 29 days or fewer. But then extensions may take it and make it become a normal rental. And I've seen people be cute about it. And listen, there's no cute when it comes to the Department of Real Estate. If you're doing a long-term rental, but you're doing it in pieces, then you know what, you're going to have to be really sharp to get that going. So I advise against that. But that's just kind of my drift. I like the Department of Real Estate. I need to stay on the right side of the fence with them, and that's my goal here today as well. Okay, so trust funds, CAR has omitted the forms. They've gotten rid of. They're not in the library anymore. And part of the reason behind that is that, well, nobody was using them. And I say nobody. They're very, very limited use. As I said a second ago, most of the companies that are doing property management have their own software, have their own forms. So that's why you won't find those in the library. And I was asked a really good question the other day about the some answers on the state exam relative to the forms, and whatever the entity was that was teaching it or testing on it, we don't have them anymore. So I don't know why that was still in the testing material, but again, yeah, see me later, chat with me, and I can maybe go over what some of those things could be. But again, what they're doing now is what CAR is doing is referring people to the Department of Real Estate's website. If you are going to need to use those forms again, and those forms that they created at DRE are really for reference purposes, but people use them. But you can go ahead and use the DRE forms. When we used to take checks on behalf of property owners in terms of rental properties, we would always use those forms, and every agent in our office had a different accounting, so we had multiple variations. Everybody had their own name on their own page, as we say. So again, if you're doing property management and you want help with that, you can always reach out to me. I'm here to help. Okay, so then let's talk about some of the forms that must be included in all of the leasing situations that you do, whether they are leases or whether they are property management. So I'm going to start off with a disclosure regarding real estate agency relationship. Now, literally, I've spent probably 18 hours creating this presentation, and so I realized that here's 4 forms: residential environmental hazards booklet, water heater statement of compliance. And so what I've done, let me show you. I'm going to take you into the here we are in our property management template. Okay, so we created this, it's called a lease listing template because that's what CAR called it, but this is our property management template. And so in the PMA side, we have PMA, which is property management agreement. We have the lease agreement, separate issue. We have notices to the tenant. We have disclosures and advisories. Okay, and so when I go into the PMA, I see my property management agreement, my property management addendum, my modification of listings. You see all these forms are just at the point of taking the listing, okay, for the property in the property management. But then I have my lease agreement, and that's going to be, so remember the property management agreement, it's a state exam question, folks, for any of you that are working on upgrading to broker. And the state exam question says, who is the property management agreement between? And it gives you 4 answers. And the most commonly picked answer is between the landlord and the tenant, and that is incorrect. The property management agreement is between the landlord and the property manager. Okay, the lease agreement is between the landlord and the tenant, or we're gonna change some names on you, and I think it's kind of cool. We're gonna call them the rental property owner, right? Rather than, we don't like landlord anymore. They just did this in the last publish. We got rid of the word landlord. It kind of goes back to the medieval times in English common law, where you had lords and fiefs and serfs and things like that. So they felt like it might be discriminatory. So we've changed some of the names, and I'm going to show you that. Right now, I'm just giving you an overview so you can see what these are going to look like, and then we're going to hit each one of these individually. Okay, so these are the lease agreement forms. Then I have my notices to my tenant. By the way, some of these are San Diego forms, like the mold advisory down here. That is the most frequently used form in the San Diego Risk Management Library, and I think it's a really good form. CAR has come out now with a new one that we'll talk about in just a minute. But then I also have my disclosures and my advisories, my bed bugs and things like that. And so, and then there's my environmental hazards. And we're going to spend a minute on that because that's really key. But I wanted you to see this because I want you to see that it is not a simple issue. And so if you are just doing a lease, I'm just helping them do the lease. Which one of these did you miss? or how many of these did you miss that you have to do? Did you notify the tenant of the fact that you were going to do a background investigation on them? They have a right by law to know that you are investigating them. Okay, perhaps on behalf of the owner. All right, even if you're paying a company $35 or whatever to do the investigation for you, you have to notify the tenant that that's happening. Okay, so with that being said, let's go back over to my I want to do now, I want to actually go to the forms themselves. So here's where we were as I showed you the four. And by the way, my entire presentation is based on, I typed out every single form, but I want to cover those with you individually. So let's do that. The granddaddy of all of them is my agency disclosure. And so when I'm doing property management, when I'm doing leases, I'm doing property management. So, the law says, and it's right here in the first sentence, that if the lease exceeds a year, then you have to have the agency disclosure. I'm going to tell you that my advice, my non-legal advice is I would do the agency disclosure under all circumstances. I don't care if it's a 2-week rental or a 1-month rental or a 6-month rental. I'm doing agency disclosure, even if it's not required necessarily by 2079.13. I'm going to do it anyway. I would advise, that's my non-legal advice. I would advise people to definitely be using this form. Okay, and you'll notice it still references buyer and seller, but when I get down here, I get into landlord and tenant. I made up a property management company and put my name in there just so you know that would be where the agent signs it, okay, or the broker associate. Okay, so that's my agency disclosure form. I don't know if there are going to be any questions on that, but the second one that we'll talk about, we'll talk about in a minute, but not yet. But we're going to talk about the California Consumer Privacy Act advisory, and this has been updated. This was just updated. So if you are using an old form, or if you are copying transactions, folks, then that means you're probably not using the current forms, which means you have not done the proper disclosure. And this is the biggest problem that I have in our offices, that I have agents who will, not the biggest problem, but I'll have agents who will just be so proud of the transaction that they did that they'll just copy it from transaction to transaction. And I had one where they literally, there was a form, the old DA form, the disclosure and consent for representation of more than one buyer and seller. Well, we got rid of that in 2012. It became the possible representation of more than one buyer and seller. And so here I see this old DA and I go, wow, where'd you get that? And unfortunately it was fairly recently. So, it's not good, but that we just get into a routine. And yes, our business is a rote business, but again, if you take your template, and again, as I said to you a second ago, when I created all this is a template, which means when we update the forms at CAR, they will update my forms in the template automatically. Okay, they update the library, that's up here, and they update the template. They will not touch a transaction in progress, and that's why your copying transactions becomes a transaction in progress. Does everybody agree with that? Listen, I don't want anything to happen to you, and it's kind of one of my big pet peeves is that we do get stuck on that. So the second big thing that I did talk about was that environmental hazards. Now, a lot of times, when you do any real estate transaction, again, homeowners, buyers, landlords, and tenants. Anytime you do a real estate transaction, you have an obligation by California law to disclose the environmental hazards that may be out there, okay? And this is not a small form. This is 48 pages of happiness, all right? So as you can see here, there's a lot of material here. Asbestos, radon gas, all this kind of stuff, right? There's a lot of material there. This is just the first page. The reason we broke it down into 6 sections was because you can't send it even in DocuSign or AuthentiSign. You can't even send it in a thing. It's too much, right? So what we've done is we've broken it down into its component parts. So the first part is the environmental hazards. Now, when you do the sales transaction, I'm sorry, I started to say that, you'll order a natural hazard disclosure company to do a bunch of stuff, and you just assume that this is included in it. But there isn't such a thing when it comes to doing property management or even doing leases. So you must make sure that you've included this because it is required by law. So even though you've kind of figured somebody else took care of it when you did a sale, in the rental side of things, you must do this. So this is the first page. The second page is protect your family from lead in your home. The third page is going to be my home energy rating. And again, it's not me making this up. This is the law requires these things. Okay. And then the fourth one, of course, is my, due to the file size constraints, you're going to have to access and email all 5 of the following separately as listed below, because they're just humongous files. Okay. And so, and I think, by the way, when I look at the pretty graphics and things like that, a lot of times that takes up a lot of the bandwidth of the program, but it is what it is. Okay. So here they've got 5, even though we've got 6. And so I'm trying to think of which one do they miss. So this is number 4, and this one alone is 39 pages. All right. And then we're going to have a signature page in just a second. So here's my residential earthquake risk disclosure statement. Okay. And so this is for properties that are built pre-1960 in California, right? Because, yeah, believe it or not, we have shakers in California. So here's one that you can actually fill out versus when you get it from in a sale transaction, you get it from the natural hazard disclosure company. They tend not to be fillable PDFs. So here, this one is for the seller to fill out. When you email it to the seller, they should be able to fill it out. And again, this is on properties built pre-1960. And then finally, we have our signature page, plus the little, we all want feedback, right? Did you like what you read? I plan to fix my home's earthquake weaknesses. I don't know. That becomes, in the law, we call that a party admission. So I probably wouldn't check that, but okay. All right. Hopefully you will. My home was built, we have trigger events, 1960, right? 1978 for pre-lead-based paint, or I'm sorry, lead-based paint, which is known on the DRE exam as target housing. By the way, every state, right? It's really not a law, it's a regulation. It's an EPA regulation. It's got stiff penalties, so you don't want to miss with that one. Anything pre-78, you still must use these booklets. You still must disclose, for example, here, the environmental hazards. But if you have lead, and you still must make the protect your family from lead in your home. But if your property was built pre-78, now you need the additional disclosure of the lead-based paint addendum, and we're going to talk about that form in just a second. And then you've got all this. You don't miss this, folks. This is really important. Okay, here we got the FLD. So they need to change the name of that. That's pretty funny. What is it now? It's this is federal lead disclosure. Now it's the LPD lead paint disclosure. So I'll make a note to somebody that needs to get taken care of. So so that's good. That's covering actually a whole bunch of my stuff. I have a question, Chris. Hi, we do receive a copy recording of the meeting. Chris, good question. Listen, I'm the big work product kind of guy. I want you to have what I do. Send me an email. Okay, don't put your email address in here because I'm going to lose it. Once I sign off, I lose everybody's messages, and I don't know how to get them back. So send me an email, kevin@burkerealestateconsultants.com, and I will put that put that up again at the end of our talk today. But differentiate whether you want the forms or whether you want the recording or both. Okay, it takes me a little while to put all that together. So, but I'm more than happy to have you have it. I want you to have it. Okay. And so for those of you wondering what I'm talking to one of our attendees today. When you put a question into the Q&A field, it pops up on my screen so that I can read the question. So I read the question to you so that you know what it is I'm looking at. You don't think it's just another nut, who's talking to himself on the telly, as we say. So Chris, thank you for the question. A good one. Okay. All right. So let me go back to my main screen, which had to do with the documents that we were talking about, right? So, we just went through the residential. There were 6 pages to the residential environmental hazards booklet. And so let's talk about some of these others. And again, I put them up here. I went to detail in putting them in and numbering them. So my water heater and smoke detector statement of compliance. Remember, the law still requires it. Now today, when you're doing a sales transaction, if you're using the current transfer disclosure statement, you don't need these things because they are included at the bottom of page 2. So, but for rentals, they're not there. So we need to make sure that we do that. And I'm going to show you the rental agreement here in a few minutes. And you'll see it's a complicated process. And then there's my water conserving plumbing fixtures, my WCMD, but it also includes my carbon monoxide detector notice required by law as well. Okay. And then finally, my notice that I was telling you earlier regarding background investigation. So we are going, the landlord intends to get information off of you. Now we use a service actually that SDAR has an affiliation with, that, we don't even get their social security number. It creates a challenge later if we end up having to, if the owner ends up having to chase the tenant for back rents or not paying rent or whatever, because that social security number can link them to a lot of necessary items. And so we'll see when we look at the lease rental application, or lease or rent application, we're going to call it now, and I'm going to tell you why in just a minute. But you must tell them that we're looking you up. Now, does anybody here not think that people are looking you up all the time? I mean, I know Linda looked me up, and I asked her when we first, when she was a student of mine back 10 years ago at the college, and I said, did you find anything? And she said, no. And I said, well, I'm in the witness protection program, which I kind of made that up. It's pretty funny, right? If you think about it, I'm probably as high profile as it gets, but look at all these laws, 1786. Right, you're entitled to find out from the CRA, what's in the file. So here's all that good information. So a good form for you to have. Again, more than happy to send this to you. Send me an email separately. Okay. All right. And then I've got my tenant flood disclosure, but I think I'm overshooting my target. So hang on a second. I'm gonna go back here. So my water heater, smoke detector, I combine them as one form. They are two different forms. There's my WCMD. There's my notice of background investigation. There's my tenant flood hazard, which we're gonna find. The law requires, folks, that you have that you give it to the tenant. Okay, now we're going to find that this form happens to be attached to the actual lease agreement. So I'll show you that in a minute. Okay, so I'm covering the disclosures and the addenda. I'm going to tell you, in San Diego County, it's real easy for the owner to go look it up. Who really looks up? We do, right? So here's the link to the my hazards. But if you go into the San Diego County website, they'll tell you whether or not it's in a flood hazard zone. And so if it is, you're going to check the box. The property is located in a special flood hazard area or an area of potential flooding. And these are, again, statutory disclosures. Okay, so you must by law make these disclosures. Now, I think the safer bet is to just tell everybody it's in the zone, right? But you don't want the opposite. You don't want to not be checking the box and then find out it is in the zone. So in fact, that's the genesis behind how we created our FHD, the fire hazard defensible space, FHDS form, our fire hazard defensible space form. We created that, and the assumption was it's in the zone, right? And so because it's safer to put the property in the zone than it is to try to remove it from a zone. So by default, our language says it's in the zone. So think about that. You do, follow your broker's advice, please. Talk to your broker about this. But this is a big deal. You can go look up the property. It's not that hard to do. You go to San Diego's website, county website, and do that as well. I would recommend, folks, that you have the owner do that. I know that, again, as I said a few moments ago, we're very helpful people, and I appreciate that. Listen, I'm the king of helpful, right? And so, but we have to be careful we don't overhelp ourselves into litigation between certainly what's going to happen between the owner and the tenant. Okay. All right. So that being the tenant flood hazard, then I'm going to put in my rent cap. And let me see, where did I put that in here? Let me see. So yeah, that became my next one, rent cap and just cause addendum. A lot of laws are changing. And so, again, in property management, if you're doing property management, you have probably got a really good relationship with an attorney who is a landlord's rights attorney. I have attorneys for both. I have attorneys that represent only tenants. I have attorneys that represent only landlords. And so you will find that the laws change frequently. You'll be really glad that you had a relationship with that. Again, if you're working with a broker that is property management, does property management, then they have attorneys as well. But you need to be speaking to your broker first and let them make the decision whether it goes upstream to the attorney for the company. Okay, but in most cases, this is my RCJC. In most cases, the notice of exemption is checked. Again, unless it's a REIT or one of those things. But again, I'm not going to read the actual form to you, or we will never get out of here. But rent caps, statewide rent control, it just is a fact of life now. Okay. All right. So skipping back over to my PowerPoint, I want to talk about the methamphetamine contamination notice. but only if it's applicable. Okay, so let's pull it up here. And this is my MCN. So if it's applicable, and again, if it's not, then there's no need to say that it is, right? But if the owner is aware, and listen, the owner is aware, right? If it has an MCN, if there's been a filed methamphetamine contamination notice, it's a matter of public record, and the tenant's not going to be expected to know how to find that. So you need to make sure that the owner makes that disclosure. That's not something that's a statutory disclosure, okay? And then I referenced earlier today my lead-based paint and lead-based paint hazards disclosure. I cannot emphasize the importance of this. So this is a per transaction. The penalty is at one point it was $11,000 just for forgetting to make the disclosure. Again, it's the tenant's right to have the disclosure if the property's built pre-78. I don't care, you've done a remodel. I get people calling me all the time. Well, we remodeled, we did a complete remodel. And of course, my response is there's no such thing as a complete remodel. I mean, that tells me you took it down to the concrete, which is rarely the case, right? Because then it wouldn't be a remodel, it'd be a new build. Okay, so, but I see advertisements that agents do all the time that talk about complete remodels, when in fact, you know, I wouldn't be doing that. But okay, so if the property was built before 78, all right, then you must make this additional disclosure. So we talked earlier about doing the residential hazards, right? So we talked about this form, the residential environmental hazards form, but again, and then we went into the protect your family from lead. This is in all transactions, whether for sale, whether for rent, regardless of the year built. Okay, so that's what this is. But when I get into my lead paint disclosure, this is specifically additional disclosure required for all properties that are built pre-78. Now, if we're going to get into a thing about, well, what about January 1? You know what? You are a brave soul if you think that you're going to figure this out, right? So you just give it to them, okay? Don't even talk about it. So this is, I said earlier that the mistake on that other form was it still said the FLD, which was the federal lead disclosure. Now it's the LPD, which is the lead paint disclosure. But again, it is an EPA regulation, and I got to tell you, it is heavily enforced. So if you are selling an apartment complex with 64 units and you did not do the lead paint disclosure to each of the tenants when they came in, and it was a pre-78, it is 64 units times $11,000. Okay, and so it's a significant event, and it will be an eye opener. So real important. This form, just all it does is to ask the seller, are you aware of whether or not, you know, have you had any assessments done or things like that? Remember, if we disturb more than 6 square feet, so right here, the third bold, the rule applies to renovation repair more than 6 square feet of lead-based paint in a room, or more than 20 square feet of lead-based paint on the exterior, you've got to have remediation done. All right. And so how many people do that? I mean, I was selling my mother's house in Arizona, and a guy came in and said, I don't care about any of this stuff. You know, you're going to die anyway. I'll go ahead and take care of it for you for $2,200. And I said, get out of the house, because, you know, I'm not going there. Right. So, you know, be careful about hiring people that will just, you know, forget the statutory requirements and the laws and things like that. If you know somebody is telling you, I'm going to skirt the law, you're skirting it with them. And then it becomes conspiracy, right? It takes 2 or more people to create a conspiracy. So watch out for this. Okay. You know, my house in Del Mar, built in 52, it's very clearly lead-based paint. All right. And I can tell you that if you want to know what is the big deal, you only need to watch one YouTube video on what happens to a child who's been chewing on this. It's sweet tasting, and it does permanent brain damage. And it's just so sad to see it. And so that's why we have this law. And this is the law regulation. I'm sorry, not a law, really. Regulation across the country. You must make the disclosure, and you must get separate signatures on it. So we have no knowledge of lead-based paint. I have no reports or records of any lead-based paint. And so I see a lot of these people selling houses that they bought for purposes of just, flipping and things like that, thinking that they are exempt. They are not exempt from this. Okay. All right. So for sales transactions only, the buyer's got 10 days to conduct a risk assessment. And then the seller signs it, or the landlord signs it, and then the tenant and or the buyer sign it. And then the agents all sign it. And so this is a big deal. Okay. So I cannot emphasize this enough. All right. So that's my lead-based paint. So let's go back here and make sure I'm not overrunning my defenses. We talked about lead-based paint. Let's talk about my information on dampness and mold for renters in California. And the reason I want to just spend a second on that is because, SDAR has a really good form called the Mold Advisory. I mentioned this earlier. I use it in every transaction that I do. It's hypothetically, it's intended for rental transactions, but this form is now included in the lease agreement. So the information on dampness and mold for renters in California. So we know mold is gold, right? I have a graduate certificate in hazardous materials management. I got a pretty good idea what mold looks like, but I'm never going to tell a client that's mold. I always ask the real estate agent, I say, do you know the difference between mold and mildew? And then they usually say, oh, no, I didn't know. That's right. I didn't think about that. There's a difference. Yeah, there is. So be careful about identifying something. Remember, your job is to disclose, not diagnose. So be careful about making representations about something that you do not have the qualifications to make. And so mold is one of those big issues, and mold is gold. And you walk into the house and it's got that funny odor, and you say, wow, there's mold in here. You know what? You're on the cooker. So I wouldn't be doing that. And it is everywhere. I mean, you think about it, you look at your transfer disclosure statement on page 2, paragraph C, the very first question, we added the word mold on the very first question, features of the property, and then mold was added probably about 25 years ago, so that you couldn't say no to paragraph C1 on the transfer disclosure. So the seller couldn't say no because mold is everywhere. And when I take a listing, my sellers check the box, says yes, and then they explain it later on. They just put mold is everywhere, right? Because it just is. It's part of the life process, chlorophyll A, photosynthesis, all that kind of stuff. So listen, do not discount this. This is really, really important. There have been a lot of high profile lawsuits over the mold issue. Have your client have it checked out. That includes the tenant. So I actually had an applicant on a property on Carmel Valley Road, property that I was doing the lease for. And they came in and they made a big deal out of getting a home testing kit for mold. They went down to Home Depot or Lowe's or something, and they got a testing kit. And then they went through the property, and then they came back later on and said, we're not going to take it because it's got a high instance of mold in it. And so you can see the Pacific Ocean from this place, and that's immaterial, but it has mold, and it has a high concentration of dampness, etc. And so I asked them at that point, I said, where are you living now? And they told me, and it's a block away from the water in Encinitas. And I said, have you ever had your house tested? And they said, no. And I said, well, why don't you go test the place you're in right now? And so they ended up doing that and finding out it was actually a higher level of it than the place they were looking at renting. Needless to say, we didn't rent to them, but because sometimes these are just trigger terms, but dampness is needed for moldus to grow. And so it's really hard. In my houses, I have dehumidifiers to get that out of there. So this is a really good booklet. If you've not looked at it before, this is included in the lease agreements now. So what kind of health problems could happen, things like that. I'm very familiar with some very high payoffs on health related issues that are caused by this. I bought a property that had Stachybotrys in it, and it cost me a lot of money to get that out of the property. And that's not quite what it looked like on your screen. This is what it looked like in that property, and it was just everywhere. And so it even got in between the curtains. So folks, it's a big deal. Don't discount it. And if somebody tells you that they have a sensitivity to this kind of thing, make sure that they check it out, satisfy themselves as to the requirement that they personally may have in the rental. Okay, so So that's my information on dampness and mold for renters. And again, I will send all this to you, but you have to send me an email because I don't just send it to everybody in the class. Although I guess I might talk to education. They're busy. They got a lot going on. We used to try to send everything out to everybody, but and again, as I said, I lose everything when I sign off. So fair housing and discrimination advisory. Now, folks, if you've been to enough of my presentations, you know that this is one of those forms right up there with what took us so long. It's just so upsetting for me that with the situation the way it is, and I mentioned at the beginning of class that I'm creating a class for DRE approval on fair housing and on implicit bias. And again, they're requiring implicit bias from effective the first of this year for people renewing their licenses. If you're just getting your license for the first time, you don't have to do it till 2024. But it's a big deal. And that's implicit bias. Okay, so fair housing, and there's some really this form. I love the form. We revised it again in June of last year, but I frequently point people out to the protected classes, and so I also teach in other states. San Diego, California has 22 protected classes, clearly more than the other states. So they will have all of the protected classes that the federal government requires, and then they will have additional ones. And so my favorite is this one right here, any arbitrary characteristic. So we actually had a case where the seller refused to sell his house to a buyer on the basis that the buyer was an attorney. And so hey, Ginger. Refused to sell it to the buyer because the buyer was hey, Joe, because the buyer was an attorney. And of course, the attorney turns around and sues the seller and says, you discriminated against me because of my, occupation. I'm a lawyer. Interestingly enough, the court held no. You don't have the protection of any arbitrary characteristic. It just kind of cracked me up, but hey, there's one for the Gipper, right? But anyway, so be careful about making statements about what you think the law is. For example, in Virginia, where I'm also a broker and I also teach their educational courses for getting a broker's license, et cetera. One of the characteristics that is singular to Virginia is elderliness. So, if you are over the age of 55, you are considered a protected class, but they also protect military status, which California does. And a source of income, right? So like Section 8 housing, like you see it right here. So, but California is definitely the leading authority on the subject, and this is something you don't want to have to learn in court. And so the violation, and if you're getting my newsletter, I have it broken down on the violations. And so your first offense is like $64,000. Your second one's $128,000, and they just keep adding it up and adding it up per offense. But nobody is ever, only responding to one complaint. It's always 8 or 9 or 10 complaints, right? So be careful. Behave yourself. The Newsweek, they did a thing, I think it was out of Rhode Island, and it was just disgusting. I mean, it was just the behavior of people to each other. You don't think this still goes on. And again, I'm getting a little crazy. I'm sorry, but this is terrible. But here they had it documented. They had hidden cameras and all kinds of stuff. It's just wrong. And so we need to fix this. So this is a great form. I really like it. There's some stuff here that I would want to add to it, but notably, take a look down here on number 8. And the reason I'm calling out number 8 is because it's examples of conduct that may not be motivated by discriminatory intent. So the law distinguishes between discriminatory intent and discriminatory effect. So whether you intended to discriminate doesn't matter if you had the effect of discriminating. So I reviewed a flyer for an agent. The flyer said, get out of the neighborhood while you still can. I don't know if you remember your state exam. That's blockbusting, or otherwise known as panic selling. And so I said, well, wait a second, where is this coming from? And their response was, well, they're building a water treatment plant next to the community, and so it's going to affect the property values. I said, but that's not what it sounds like. So and this agent was, loves everybody. So it was just, and so we adjusted the marketing that the agent was contemplating, but you need to be aware of this. And so we see this. So you all know in your listing agreements today, by default, it says no buyer interest letters. We used to call them love letters, but then I think CAR rightfully changed it to a more appropriate term, which was a buyer interest letter. This is across the country, and I speak at this at NAR. So it is very, very important. The seller taking those, we did them for decades, didn't we? Right? A picture of the family and all that. We had a lawsuit where the buyer sued the seller for not accepting their offer. It was 8 offers on the property, but theirs didn't get accepted. They had sent over a picture of the family. The daughter's in a wheelchair. There's race issues and things like that. And so guess what? You're asking for it. And so that's what this talks about: unconscious bias, right? And again, as I said earlier, implicit bias. But this is a good example. Refusing to rent an upper level unit to an elderly tenant out of concern for their ability to navigate the stairs. I mean, that's an example, folks. I mean, you just take it for granted that they can figure out whether or not the stairs are going to be a problem for them. A house with a pool to a person with young children out of concern for the children's safety, that can be discriminatory effect, right? And so, we want to let the parents make the decision on that. I know that most of my owners, when they buy investment properties, they fill pools in just because they are concerned about the safety, but now they're leasing the property without a pool. So, but just be aware that sometimes we can say and do things that are definitely going to create problems. And number 9, examples of unlawful or improper conduct. And again, here's my example of block busting, otherwise known as panic selling, and things like that. So we all really need to spend 20 minutes and read this form. Refusing to rent to someone who's wheelchair, so you need to read the form. Okay, is that good? I'm not spending more time on this, but obviously I'm creating a 3-hour class on it, so we're not going to do that class today. There are some exceptions to fair housing requirements, but the law says that anytime the real estate licensee is involved, there is no exception. So if you have a real estate license, there is no exception. Okay, so get rid of that right away. Okay, all right, so good. So we talked about fair housing and discrimination advisory. Again, one of those forms that I have in my quiver of arrows that I say, what took us so long? This needed to come out a long time ago. And now you see the states ramping up, requiring additional educational classes and things to make people aware of when these things are happening. Okay, all right, so that's my fair housing. Let me get back to my PowerPoint. So let's talk about my wire fraud. Now, I'm going to tell you there's a couple of rules out there that cause me concern, and we're going to get into the really big forms here in a minute. But whenever I've got the possibility of the transfer of funds, and so I've got a tenant in one of my properties that I own, and the tenant says, I'm going to Zelle you the rent. And so, look, this is gray. Okay, so I'm not really 100% okay with those. I like getting a check in the mail. All right. But anytime you are wiring funds, whether it's from the tenant to the owner of the property, or even to you, that wire is always suspect. And so what happens today, usually in sales transactions, they're targeting that escrow money coming into the escrow company. And so we have all of these notices that go out, oh, by the way, we changed our wiring instructions, but all the escrow companies and all the intelligent brokers have a disclaimer that says, I'm not going to give you wiring instructions. Even us, to get a commission check, not only do we have to sign the acknowledgement, then we also have to speak with the escrow officer directly before they're going to wire us our funds, making sure that we have the right wiring account and things like that. So I know of a case, $1,000,001, and that's nothing in today's dollars. This was a couple of years ago. Got wired to HFC, Housing Finance Corporation, in Hong Kong, and it was gone. And normally, if there's a problem with wiring instructions if you can get it to the FBI within 24 hours, there is a remote possibility that they can get the money back, but that's not always going to be the case. This has grown to be a huge issue. When I first spoke with the FBI, they came to our meeting at the actually it was in Indian Wells 8 years ago, and we just had another one, but in Indian Wells, and they said, it's on the rise in real estate. You are running now, between 12 and 16% of your, of our cases on wire fraud are happening, and by the way, a federal offense, right? Okay, so, but do you think the bad guys care? No. So anyway, today it's almost half of our transactions are getting hit by this. And then when I was at the NAR meeting in Florida back in November, I actually was there, I spoke at that. The FBI was there again, really good PowerPoint on all that, on wire fraud issues. If and they did, if you want a copy of that PowerPoint, send me an email. They weren't hiding it from anybody. They want people to know about this. But there's another set of rules in California that says that if the owner, we're going to see this in a minute, if you accept rents by wire, remember, you don't have the protections of the NSF laws anymore. So the insufficient funds laws, a bounce check, for rent, you are subject to treble damages, things like that. But wire, we haven't figured that out yet. So just be aware, that have this in all of your rental transactions, okay? And then my California Consumer Privacy Act advisory, and again, I'm very sensitive to this time, this date up here. And so when I tell you, be sure you're using the current form. So the wire fraud advisory and all of these were updated literally an hour and a half ago. So, I literally download everything right before a presentation to make sure I have the most current version of everything. And I was deleting stuff that I did for my November presentation that were no longer applicable. Okay, so when I'm looking at this one and I'm seeing 1222, I'm telling you this was updated. You don't want to be using the one from 1221. Okay, you need to use the current one. Forget the fact that you don't have protection from the user protection agreement at CAR. You just want to make sure that your client, the requirements at law for disclosure have changed. So we want to make sure we're using the current forms. Everybody okay with that? All right, so let's talk about my bed bugs. Believe it or not, bed bugs, alive and well. It's a law. It's Civil Code 1954. Okay, it sounds like one of those hokey things, but look at this. We just did this in 18, and here's this whole great big thing on bed bugs. Now we're going to see when we get into the lease agreement that this form is included with the lease agreement. So but there are laws that impact the property manager see, we still have landlord, it should say rental property owner, that affect their ability to rent the place. If they know about bed bugs, they may not rent the place. So rent the place out. You see what I'm saying? We say let, right? So this is a big deal. Okay. Then we have Megan's Law, and so it's kind of, we don't have this included. I think we just now have included this in our lease agreement, and I'm pretty sure I just saw it. But if you're not using the current lease agreement, you need to be making the disclosure. And again, remember that the law requires that you and I disclose the existence of the database. It does not require that you and I go to the database. I'm not going to the database. I've never been, okay? In the beginning, when they first came out with the database, you had to go down to the sheriff's department. They took they created another database with your information as you went through the booklet. Listen, this is a serious issue, but then the Department of Justice was required to create a website. And so you see it right here, meganslaw.ca.gov. And so I made a comment. I said, I've never been to the database. And the reason that I don't go to the database is because I don't want to be held to have constructive knowledge of everyone who is in the database. So in deposition, why didn't you tell the people that the next door neighbor was in the Megan's Law database? Well, I didn't know they were in the database. So this is the real estate agent responding. And then the attorney says, well, when's the last time you went to the database? And you say, well, I went to the database 3 months ago. And then the attorney says, well, they were on the database 3 months ago. Why didn't you tell the buyer that there was a registered sex offender? And these are just the registered sex offenders, okay? you can see how this goes, and it gets worse, right? So, listen, I like being deposed, but these are the kinds of things you're just not going to be able to do that. I was in a deposition the other day, and the attorney said, where are your text messages? And I said, I have a policy, I don't text. So I have no real estate related text messages. And it confounds a lot of people who think, well, what kind of a kook doesn't text with their clients? And the answer is the Department of Real Estate. Hi, Kathy. The Department of Real Estate made it pretty clear. I was in a panel with Veronica Kilpatrick, who I have a tremendous amount of respect for. She's the district manager for LA and San Diego County, and Gov Hutchinson and I and Robert Sunderland, who's just a brilliant, he's one of the Crest attorneys. And listen, we all agreed, do not text with clients. I know people do it. One of our own brokers said, come on, Kev, you got to get into the 90s, right? I was like, I'm not going to do it. Anyway, so this poor attorney who was asking me for my text messages had essentially committed her whole day to going through my text messages, and I don't have any. So, I text with my agents, I text with my family, but I'm not doing it with clients. So I got off on that. But Megan's Law, back to Megan's Law here for a second. So the Megan's Law disclosure is critically important. And I'm pretty sure we've added it now to the form. We'll see in just a second, okay? But if it's not there, you must make the disclosure, all right? But do not go, well, I'm sorry, you do what you want to do. But again, you would be held to have constructive knowledge of everyone who was on the database at the last time that you went to the database, okay? By the way, it was interesting because Pete Selecki, and I love Pete, he's our attorney now for general counsel for SDAR. And I had him speaking at my law class up at Miracosta, and I made a comment. I said, that if you are on the database, it's actually illegal to go to the database. And he just kind of chuckled. It's like, a lot of people don't know that. It's actually $1,000 penalty. So hopefully it doesn't apply to anybody here today. But if you're on the database, it's against the law for you to go. I mean, why would you go? You want to see what your picture looks like? It just doesn't make any sense. So this is serious issue stuff, and now new laws that are being put into effect about releasing, registered offenders into neighborhoods and things like that. So, folks, it's a hot topic. It really is. So that's my Megan's Law database disclosure. Let's take a look at my. So which one is this? This is my. Oh, yeah. So now I am overshooting my target. So I mentioned this earlier, and so let's go ahead. I'm going to pull up my catch up to where we are. Bed bug disclosure, periodic pest control. We don't have a form for that. We do have Megan's Law database disclosure. Military ordinance, again, statutory disclosure. If you're renting properties in the Tierra Santa area, then I would be using the local area disclosures that San Diego has in their risk management library, because you need to make these disclosures. Service Members Relief Act also in there. We don't have a form for that. LAD, folks. Death on the premises. So remember, the law requires that you disclose, it's Civil Code 1710, the law requires that you disclose a death on the premises. Now, folks, that doesn't mean in bedroom number 2. That means anywhere on the property, okay? So death on the premises, you have an obligation, the owner has an obligation at law to make that disclosure if the death's occurred within the previous 3 years. Hi, Virginia. If you got a question, Q&A button, if you wouldn't mind, just type it in the Q&A. You have the owner has an obligation to make that disclosure. Hypothetically, you're not aware of it. Okay. All right. So let's talk about Virginia. Are you high-fiving me? Okay. Okay, you got your hand up, but go ahead and type your question into the Q&A field, because I can't unmute people, because if I do, then if I try to mute them again, then it gets crazy. I think you're high-fiving me though. Okay. All right. Okay. I'll wait for your question. If you have one, you keep raising your hand, but, Virginia, can you type it into the Q&A? Oh, there you go. Okay. Monica typed it in. Okay. So death on premises only within 3 years. Great question. Okay. So, and again, I teach this stuff. So, unless it's a heinous act, so like the Heaven's Gate, I think that carries with the property. I think if it's a stigmatized property, that's a separate issue. But I also think that the Sharon Tate murders, I mean, she would have been 72 years old today, right? Those are heinous acts. I think they carry beyond 3 years, but I think not because of the death, but because of the act. Okay, so the death itself maybe not requiring the disclosure after 3 years. And by the way, if asked, the owner has to tell what they died of, unless they died of AIDS, in which case, or HIV related illnesses, in which case they don't have to disclose the manner of death. And so, of course, if they say I don't have to tell you, then you know what that's going to be. So yes, Monica, so death on the premises for sure within 3 years. And again, you can look up the civil code on that. I'll send it to you. If you want to send me an email, I'll send it to you. Virginia, good question. What is the difference between red and black font? So the law says that certain disclosures must be in red if they are the same size font as the rest of the document. So if the document's in 6-point font, which it is, then there's a statutory disclosure that requires a red font, then you put in, it has to be in red. Well, when we created our forms at CAR, we don't know if you have a color printer or not. So the law says if not red, then 10-point bold. Okay, so that's where the black font comes from. So 10-point bold font. So that's why you'll see like arbitration disputes, 10-point bold font, things like that. Okay. Thank you. Good question. Lena, Megan's Law. Tenants are responsible for checking details. Absolutely. Lena's making a really good point. The tenant is responsible to see to investigate the property, right? Much like a buyer would be responsible to investigate the property. So the tenant is responsible. As the agent, you only are required by law to tell them about the existence of the database, okay? Unless you have actual knowledge. And if you have actual knowledge, it's a real sticky issue because you could be saying so-and-so is on the database, and then it turns out they're not on the database, you were mistaken, or it was a rumor that they were on the database, they're not on the database. Now you're going to probably get a civil suit from the person that you have indicted, or what's the word for it, that you have called out. Okay, so Monica, I lose everything in the Q&A field when I sign off. So send me an email separately to kevin@burkerealestateconsultants.com. I'll pull it up at the end again so that you all can see it. But I want to, and again, tell me specifically: do you want the recording? Do you want the forms? Or what did I mention a second ago? Look, I've already forgotten it. The FBI's PowerPoint on the subject. So happy to send all that to you. Be clear though about what it is that you're looking for. Okay, Virginia, I'm going to lower your hand only because I think we answered your question. So let's talk about my rental, my property management agreements, and we're going to talk about the types of agreements, and we're going to talk about 4 of them. We're going to talk, well, we've got more than that, but we're going to talk for sure about the property management agreement, and then we're going to talk about the rental property owner disclosure, which, by the way, the RPOD, which is also included with the property management agreement. So question, death on property. I had a friend who died. Okay. That's actually going to sell it. How do you disclose the death on the property? So that's a very good question. So there is no place on the TDS for death to disclose the death on the property, but it is a statutory disclosure. So CAR came along and created the SPQ form, which includes the place for in the first set, because it unpeels the onion that the TDS didn't answer. And so now you use the SPQ in all of your transactions in California, and you check the box that says, the seller checks the box that says death on the property, by statute. Okay, good question. All right, good. Okay, so let's take a look at my property management agreement. And so again, the property management agreement, like the other forms, starts out with a mini template. Here's my agency disclosure. Here's my fair housing and discrimination advisory. Here is my, and then I get to my property management agreement. Now, by the way, there are more addenda at the end, and I'm going to show those to you here in a second as well. So like the other forms that we have, we've got our date prepared, the name of so we've changed the name of the landlord to the RPO, or rental property owner. So now we're no longer using the word landlord. We've stopped calling them serfs, that kind of thing, except in San Diego, of course, because serf's always up. But rental property owner instead of landlord now, and now the broker becomes essentially the property manager. Okay, and so in drilling into this form, without I might have a little bit of time to do this, but always a beginning and an ending date. And if you look at the new buyer representation agreement, you will see it's creating a lot of anxiety among the legal community because it has a beginning date and then it says so many days after the beginning date. And so the attorneys that I'm talking to are like, what happened to ending date? You know, the DRE requires an ending date, you know, a termination date. Okay. And so now, you know, what is 10 days, you know, starting on what day, you know, things like that. So notice by one party to the other. Early termination, I don't know, in our office, we're not going to allow early termination. We're going to have termination for cause, property manager's acceptance of the agreement, and then the authority and powers that they are given, the rental, leasing, and direct electronic rental payments. And I said I would mention this only because there's a clause down here in 3B4. If the RPO, the rental property owner, permits the tenant to pay rent by direct deposit, such as wire or electronic payment or some other method, then the RPO should discuss with the landlord tenant attorney the implications of doing so in the event that the tenant defaults. So again, as I always say, everybody's kissing on the lips until all of a sudden something goes wrong, and then they want to talk to the attorney. They need to talk to the attorney ahead of time before you start allowing that. The tenant that came to me with wanting to do the Zelle or Venmo or something, I would just instantly had a problem with it, and it was a disaster. They tried to send the rent on the first. The bank would only let them send $1,000. The rent was clearly higher than that, and so then they started sending it in increments, but they wouldn't let them send it but every 5 days. And so hey, you're late, right? So that's kind of my position. And folks, I've got tenants in properties over 15 years. I take really good care of my tenants, right? But I expect them to get the rent in on time. And these are good tenants, right? But we're not doing that anymore. We're doing a check, and they send the check to me 10 days early. It sits up on the countertop and along with all the other checks. And they know I'm not going to cash it until the first of the month. But again, that's a property that I own. So I am obviously I don't need a property management company to do my own property. So understand, then we also have included in there my wire fraud advisory. Okay, so you need to read the form. All right, termination, repair and maintenance. And again, this is the property management agreement. This is between who? The rental property owner and the property manager, in our case, the broker, and third-party vendor services. This paragraph gives the broker permission to interact with those persons that the RPO has hired, and hold me harmless, that kind of thing. But then one of my favorites is expense payments. So, a lot of times you hire a property manager and you say, no, you do everything. Well, no, you don't do everything. So as a property manager, you may do a lot of things. Listen, I think that real estate agents are grossly underpaid. I think they should be paid a lot more than they get paid. But at the end of the day, it's a decision, right? And it's the broker's decision as to what the minimum fees might be. And so I have a property management company that I'm helping them, and they looked at this and they went, oh, we've been paying all this stuff for people and not charging them for it. So this is set up automatically so that the RPO pays these items, and and by agreement, the RPO has agreed to pay it, because you certainly, as the property manager, you don't want to find out that they're not paying their taxes, for example, or the broker can pay it. I don't know. My counsel is let the RPO pay it, but in some cases they really want the property manager to take care of these things. So, okay, we're going to talk about charging for that in just a second. Okay, so limitations on payments and exceptions. If I spend any money as a property manager in excess of X, we're going to determine that figure here. Security deposits, this is why I said earlier, you're handling the money of others. And in most cases, in a lease agreement, the security deposit might go to the owner. But in property management, it's almost by default going to have to stay in the broker's account. And we're going to call that the trust account, right? Because it has to be an account separate from the broker's money. And remember, in property management, you have limitations on how much of your own money can be in there. The limitations in California are $200. So, and that's to cover, bank charges, bounce check fees, things like that. So there's a purpose behind why you're allowed to have 200 of your own money, but not more. And if you put more of your own money into an account, then that becomes commingling. And that's definitely something that not only the law frowns upon, but also the Department of Real Estate frowns upon, because if you've got commingling, you probably also have conversion. Because if you put $500 of your own money in the account and then you go and you pay for something, well, they don't know what of that money was yours and what of it was belonged to the property owner, the RPO. I remember I was in a meeting with the commissioner, boy, probably 15 years ago. And I remember that the commissioner made the comment that they had a broker send up their license renewal check, and it bounced. Now, listen, if I was going to bounce a check, it wouldn't be to the Department of Real Estate. Okay. Well, anyway, this broker bounced a check, and it was on for renewing their broker's license. And it was written on the trust account. They got the check back. They're looking at it and go, wait a minute, this is on the trust account. So trust account is other people's money, OPM, right? So they said, we didn't even call the broker. We just sent a whole bunch of people down there, grabbed all the books and everything. The guy was paying his landscaper. He's paying his electricity bills. He's paying his own personal expenses out of the trust account. And so the department asked him, said, well, you're familiar with commingling and conversion. It's on the state exam, right? And the answer was, what happens when you ran out of money? And he did. Obviously, bounced a check to the Department of Real Estate, and the response was, well, I just put some more of my own money in there. And so they took this person's license. So I mean, it was a real short interview, shall we say? So be really clear about that. Read the trust funds. This is, and again, I mentioned this earlier. The California Association of Realtors has deleted the trust funds account trust forms out of the library, and they are referring everybody over to the Department of Real Estate, because the Department of Real Estate has some pretty good basic forms that cover the requirements for the trust fund account. Okay, so just remember, it's money, other people's money. We need to take care of that. So reserves, how much money can the property manager leave in the trust account? What about disbursements? And we're going to talk about that. This L gives us the level of disbursements in what order. And then remit funds monthly or yearly or 6 month or whatever. Statements, separate issue. Property managers funds, key safe lockbox addendum. We're going to talk about that in a couple minutes. Mail forwarding. This is a favorite of mine. Under no circumstances shall a property manager be responsible for the forwarding of any mail directed to any previous occupant, all of which may be refused and returned to sender. And I had a property management company ask this, and they're a good company, and they said, what do we do with all this stuff? And I said, if you're using this form, pitch it. Notify, if you want to, as a courtesy, notify the tenant, but I wouldn't make that a practice. And so it happens. People forget. I bought, Linda bought a house and continued to receive letters on behalf of the previous owner for 3 months after she purchased the home. So she finally, they would come down and pick them up and all that. It's like, did you put in the forwarding order at the post office? And so you're not responsible for that forwarding order. Needless to say, she just started pitching it. Okay, so rental property owner's responsibility. So the paragraph number 4 is what the rental owner is responsible to do. The rental property owner is responsible to do. Paragraph number 5 talks about representations that they are making about the property, like I'm current on my mortgages and things like that. And then tax withholding. This is a big issue. This form was completely revamped. I like what they did to it. I think they did a really good job, but we needed permission to withhold the owner's funds if the owner was not a California resident. So notice that paragraph number 6, if not a California resident or a corporation or LLC qualified to do business in California, that you're authorizing the property manager to withhold what? 7% of the gross, right? For anything exceeding $1,500 in a calendar year. So, but there are ways around that. The RPO can do the form 589 or the 588, those kinds of things to avoid having the withholding. But as a property manager, you're required to withhold. And we're going to see when we look at the property management agreement, the addendum, and here's the property management addendum. It talks about authorizing the broker to remit trust funds of the owner, right, to the California Franchise Tax Board, and for withholding taxes when the owner is subject to non-resident withholding. And remember, there's not only the California withholding, but there's also the federal withholding. If they're not even a U.S. citizen, then there's going to be additional monies, and that's going to be 30%. Down here, 30% of the gross rents. So, so be aware of the fact that you now have in writing permission to withhold those monies, and don't just have the owner sign this. Make sure they understand what they're signing. Okay, and then paragraph number 6C just says, hey, we've got a legal obligation to report rental income to, it's Form 1099. So, it's not just us doing this because we feel like it, but it's actually a law. So I mentioned earlier about the different things that the RPO could give the broker authority to do. Paragraph number 7 talks about charging for those things. So, if you don't think this is a big deal, look at preparation for pre-litigation. It's a big deal because, listen, you're going to get very familiar with the legal process if you're doing property management because, tenants have problems and things like that, and they don't pay the rent or whatever. And so you're probably going to spend some time in court. So do you charge extra for the preparation of the file for that? And the answer is, if you've given it to them in writing, as you have here, then you can charge separately for it. But unless you've got your own separate contract for all of this. Joe, are there any requirements in the agreements that the tenant upon moving provide a forwarding address at a certain time, only if they want their deposit back? Good question, Joe. So tenants leave properties. The tenant on the move-in, move-out, actually now only the move-out form, they bifurcated it into 2 forms, but on that form, it actually says, send my deposit to this place. Because remember that the law requires that the owner of the property return the tenant's deposit or an accounting thereof within 21 days of the tenant vacating the property. Now, all states have different requirements. Virginia's 45 days, but California 21 days. So return the deposit or an accounting thereof, which means if you took money out of the deposit to cover items on the tenant, then you can take that out, but you've got to give them an itemization for doing that. Well, obviously, the tenant, and I've had this happen many a time where the tenant's standing there with the keys and say, I'll give you the keys, this is the day of move out when you give me my deposit. And the answer is that's not what the law says. So until you give me the keys, you are still in possession of the property, and I'm going to prepare the eviction because your lease is over. So again, I'm very fair with my tenants, but I'm very clear with them what the responsibilities are. And so, Joe, you're right. If I don't have a forwarding address, then how am I going to send you your deposit? And again, we don't have to send it for 21 days. So I see people abuse that, by the way, and I wouldn't do that. I just don't think that's kind. But preparing the property for rental or lease, managing the property during periods of vacancy. These are all things that now you have the ability to charge for, but you have to tell them how much you're going to charge. Okay, and maybe you have a separate addendum that discusses what those things are going to be. What happens if I have to do tax withholding? I may have to charge you to do that withholding. Okay, so all right, let me see. Let me hit the hot buttons here. Before we run out of time. How many do I have to go? Oh boy. Okay, all right. Agency relationships, we talked about this already. Make sure you're doing that agency relationship form. This is the property management agreement, so it is going to fall under the purview of that. Property managers don't usually get hired for 2-month increments. By the way, property managers agreements are usually going to be at least a year or more. And the other thing to consider is that we don't know what the lease agreement is going to look like, but I would still do that, still do the agency disclosure form as well on that. I had another point I wanted to make, but I lost it there for a second. Notices, what are those going to look like? Security and insurance. Again, we don't have insurance to cover your place as the broker. So, the owner needs to maintain insurance of their own. We're not going to provide that for them. Attorney's fees. Now, this is good. So this is a departure from, and we're seeing this in the BRBC now as well, the buyer representation agreement. So the attorney's fees provision actually says that in the event of a proceeding or arbitration arising out of this agreement, each are responsible to pay their own attorney's fees and costs. Aha, that's new, right? Remember, it was always prevailing party. And so CAR, the attorneys at CAR are trying to minimize the numbers of litigations that are caused simply by having recovery of attorney's fees for the prevailing party. So I can tell you I've been involved in cases where it never should have gone where it went, but the plaintiff's attorneys misread the contract, not realizing, for example, that they had an obligation to attempt mediation first. And speaking of, I get down into my ADR, otherwise known as alternative dispute resolution, and it says in this, if for any dispute or claim to which this paragraph applies, any party commences an action without first attempting to resolve the matter through mediation, or before commencement of the action refuses to mediate after request has been made, and that party is the losing party, then the prevailing party shall be entitled to recover attorney's fees. So again, you want to make sure that that you hire, and CAR coined the term about 6 months ago, the QCREA, which is the Qualified California Real Estate Attorney. I have people call me all the time saying, my attorney said, and I'm like, I teach attorneys this stuff. Where do you get that? Oh, well, they're in Illinois. And I go, did you tell them you were asking them a California question? Because they could be disbarred for that. Of course, clearly it wasn't. So, but I have a lot of times people call me up and tell me their attorney said something completely different. And I always like to say to them, I say, hey, I don't have a problem with that at all. Let's get them on the phone. Let's talk to your attorney. I'll bet you that's not what you told them, right? So anyway, so don't get into disputes with attorneys. It's not usually a good idea. But again, we do have some exclusion for mediation. There's some additional things like a small claims court action, bankruptcy court. Anytime there's a court involved, forget it. They're not going to be required to mediate. They're never going to do that. I can just see you trying to tell the judge that they have required by law to mediate. It ain't going to happen. So probate court, things like that, foreclosure proceedings, that kind of thing, even unlawful detainer. So there's no requirement to do mediation on that. So equal housing opportunity. I'm sorry, advisory. So we've, out of the employment agreements, and this is an employment agreement, the listing agreement, the buyer representation agreement, property management agreement is an employment agreement. We have taken out the old, the broker and agent initial, this paragraph, if you want arbitration to apply. And the reason we did that was because most of the brokers would prefer the ability to discuss that rather than having their agent commit them to arbitrate. And so that's why we have a separate form for that, and that's the arbitration agreement form. So if your broker says, I want arbitration, then you need to provide that form to the RPO. Again, it'll be a discussion as to whether or not the RPO, again, arbitration, if you're going to arbitrate, you may be giving up rights that you have by law, like the right to a jury trial, or if that's what you want. But again, those are legal decisions. And so folks, you and I need to know when to back off from giving legal advice to clients. And I don't even get into this with the client, and this is a 2-hour class in my law class, is the decision to arbitrate. Most attorneys go, oh, we don't want to arbitrate, we want to go to court. And I go, I agree with you. I love going to court. But at the end of the day, it may not be the right thing for your client. And so that's what we're worried about, is protecting the client. Modification of the agreement. Again, interestingly enough, the property manager can modify the agreement, but they have to give 30 days notice. If the RPO objects to the modification, then the property manager may either rescind the modification or allow the RPO to terminate the agreement. In other words, the property manager comes up with something that the RPO says, I ain't doing that, and then they get into a headbutt about it, the RPO can terminate the agreement. But again, and then there's some provisions for that as well. So then we have our check boxes, RPOD. We're going to show you that in just a second. Fair housing, we talked about that. California Consumer Privacy Act, we talked about that. Disclosure regarding agency relationships. We'll talk about the KLA also, but that's just because we need to talk about the owner agreeing that there is no insurance, we don't have insurance to cover your stuff, and then the tenant agreeing that we don't have insurance to cover your toys. And if you've been to enough open houses on Caravan or whatever, I see some of the most bizarre things left out on, money clips, guns, things that are left out. And we need to make sure that the tenant's aware of the fact that we're not going to be responsible for any of that stuff. And so time of essence. I won't go into a contract law class here. I will be doing the buyer representation agreement. We will be talking about the time of essence clause. Legally authorized signer. So we're going to have that RCSD again. The person here is representing that they have the capacity to sign it, and if they're signing on behalf of another, so if they're a non-natural person, then we're going to have that RCSD. That could be either the seller or the I'm sorry, either the owner, landlord, or the tenant could have that. Ownership, title, and authority, same as we've had in our other agreements. Here's if I fill this in, the entity rental property owner, if I fill this in properly, I do not need the RCSD. So you should know at the time that you're doing the property management agreement whether or not you are dealing with a natural person. You've looked them up, right? So you pulled them up you pulled up the title report. Linda pulls up the grant deed. So she's pretty thorough about that. She'll pull up the grant deed to determine whether or not they own it in trust, or whether or not they own it as a partnership, or some other entity, or power of attorney, or whatever. And if it's anything other than a natural person, then we're filling this in and having them sign it. And if we miss it, then we're going to have to pull in the RCSD for landlords, which I will show you that. In fact, let me show you that now. What's this one? Lead the application extension. Here we go. Representative capacity, signature disclosure for landlord representatives. And again, there's an equivalent one for the tenant. And so it's a disclosure to one or more of the following. And I check the box for trust, or it could be an entity, that kind of thing. And so these are and then of course the landlord signs. We need to know when they sign it, they date it, not you, and then what title, in what capacity are they signing it, and then if a month to month, then they also have to have the tenant sign it. It can't just be your representation, and then the lease, at the time of the lease, time of the property management agreement. We have all these conditions in here, which is just great stuff. I like that a lot. So let me go back to my property management agreement. So that pretty much is going to wrap that up. The broker then signs it here under broker signature, and then we get into the RPOD, which is my next form. So we're moving right along. We're doing good. This was the RPOD form. Let me go ahead and go back to that really fast. So the RPOD, interesting. This is actually a disclosure from the rental property owner to the property manager. And CAR has conflicting information out there, but I understand. So this is the disclosure to the property manager, who I would assume in turn would tell the owner, you need to make these additional disclosures. So who was it that asked the question? Was it Virginia? Somebody asked the question and I don't see it in here. Anyway, okay, I'm not spending time looking for it. So anyway, look at this. This looks a lot like the SPQ. So remember what I said earlier, we have certain statutorily required disclosures, whether there's any lead-based paint, whether water conserving plumbing fixtures, my WCMD form, water heater strapping, methamphetamine. Y'all get this. Periodic pest control, we don't have a form for that, but you do have a requirement. It's a statutory disclosure, which means the law requires it. Water submeters, we do have a form for that. Pool safety, death on the premises. So, did they die on the premises within the last 3 years? If yes, does the RPO know the manner of death? Yes or no? If yes, you should disclose the manner of death, except for death due to HIV or AIDS. You don't need to go to law school to learn all this. Non-statutory disclosures: mold, okay, asbestos, carbon monoxide. Actually, carbon monoxide is a statutory disclosure. I don't know why it came under this one. Smoke alarms as well. Bed bugs, Prop 65, gas meters, electric meters, water meters, permits. These are all things that the owner should be disclosing. So if you go over this form with the owner, now you've got something that you can create for the owner to make the disclosure to the tenant. I'd be careful about that, because remember, again, we don't want you creating what you think is a legally binding form on the tenant. But you can see all this other material facts affecting the property. Okay. And then I've got here's my, listen, this is everywhere. The CCPA is just everywhere, right? So you're going to have that form. Okay. I've already shown you the property management addendum. This, in addition to paragraph number 1, there's a lot you can write in here. Again, I kind of have a problem with that myself, because I think that's where we get into trouble, because we start writing what we think is legal language. So be careful. Check with your broker before you have anybody sign it. Let's talk about my lease listing agreement. And here we go. So this is going to be my, so again, I had my property management agreement, which allows me to manage the properties of others, and it may be more than one. This is the lease listing agreement, which is usually one property, right? I lease it and I'm gone. Okay, so different than property management. All right, and so we're going to see, and I'm going to go through this pretty quick. Beginning and ending period. Again, this is between the RPO and the agent, the leasing agent. A lot of the same kind of stuff in here that was in the other. Here's my compensation, right? So we do, if you intend to be compensated for something, and then remember, it has to be in writing. So yeah, I had a call the other day where the agent said, well, the owner said they just give me $500, and it's like, give you or give to the broker. And again, you may not collect a fee unless you have it in writing from the owner, signed by the owner, along with the language that says that all commissions are negotiable at law. And so interestingly, here it is right here, the amount or rate. So amount would be dollars, rate would be percentage. Real estate commissions is not fixed by law. This language is required by law by the Department of Real Estate. Let's say that, okay? You may not receive a commission unless you have an agreement someplace that says this, okay? All right, tenants payments, how do you want it? Does it go to the broker? What happens? And then here's my direct electronic rental payments again, same language from the property management agreement. Key safe lockbox, we're going to talk about that in a minute. Do you want to sign? Are you going to, interestingly enough, the default is no sign. So you would have to check the box. I think they'll switch that at some point. But the default should say we get the sign, unless you check the box that says you don't get the sign. MLS, security and insurance again. Let's see what else in here. Again, like I said earlier, a lot of the same stuff. Here's my tax withholding, same as it was in property management. Brokers and RPOs duties, agency relationships. In property management, the chances are pretty high you're probably going to be a dual agent. So that's why it's addressed differently. But here's my attorney's fees provision again. Each responsible for paying their own attorney's fees. Like I said, there's a push in that direction. And I'm sure not all brokers are happy with that. But at the end of the day, listen, our job is real estate, not being in court. Dispute resolution, same stuff as before. You agree to mediate. There are exceptions to mediation. This was missing from the property management agreement, the assumption being that property management agreement, excuse me, is signed by the property manager, the broker. But again, the law says the broker manager has the right to cancel the agreement writing within 5 calendar days. The DRE says you must get anything material to a transaction to the broker within 3 days, and that gives the broker 2 more days to decide if they want the listing or not. Okay, and having been management, having people walk into my office with a file and saying, here, I want to get paid on this transaction, and I'm looking at it like, this is the first I've seen this. When is it closing? Well, it's closing tomorrow. And it's like, no. So, I'm going to have time to review this, and I've got other files in front of me. So, at the end of the day, remember, the DRE requires that you get everything to the broker within 3 days of it happening, not 3 minutes before it closes. Okay. All right. Equal housing opportunity. Here's some additional terms, same as we had before in the other document. Time of essence, legally authorized signer. I may get you done here by certainly by noon. But please ask questions if you have a question. Legally authorized signer, again, if I know that it's going to be an entity, remember that they're required to give you proof that they are authorized to sign on behalf of the entity. So if they are a corporation, and this is going to be in my class, that's one of the test questions in my class that I have up for DRE approval, and that is that they have to, if it's a corporation, it has to be statutory agent. If it's a trust, you need a trust cert, something that proves that these people are able to sign on behalf of the entity that they are claiming. And so, it's interesting. I got an email from the Secret Service the other day about people trying to sell vacant land. And they of course they're from out of the area, they're in some other country, and now there's this huge scam going on where people are representing themselves as as owning a property, and then getting real estate agents to list the property with the assumption being that they're going to get some money out of the entity will get some money out of this thing, but of course it turns out they're not even on title. So be very careful about that. If you want a copy of that Secret Service announcement, send me an email. I will send it to you. And then what else in here? So needless to say, I'm in this all the time. And again, this is my lease listing. Here's my RPOD again. And this is going to be 4 pages long. Same stuff. We've already gone over this. Okay. Then I have my Fair Housing Discrimination Advisory. And then I have my California Consumer Protection. Right. And what's missing? My wire fraud advisory. Was that up here at the beginning? It might have been. This is an example of, no, it's not. So make sure you've got that wire fraud advisory in there, because the tenant's going to say, well, I didn't know, or whatever. Question. Email sent to request. Yes, thank you. Yeah, just don't put your email in here because I'm just not going to see it. I can see it here, but when I'm done with the presentation, when I sign off, all this goes away. So send me an email. I will send you the Secret Services announcement. Kevin@BurkeRealEstateConsultants.com. So that's my lease listing agreement. And then here's my lease agreement. So a different animal. I got another request here. Joe, is there a requirement to approve leaving the lockbox somewhere on the property to allow vendors access to the rental property? Yes, that's going to be the KLA. And again, even though listing agreements have the language authorizing the broker to put the lockbox on the property, I like the KLA. It's much more robust. Technically speaking, if you have the listing agreement, you've been given authority to put that lockbox on the property. And if you're going to have vendors access the property, so I do not do push button lockboxes, right? So I use the central lockbox. It is the lockbox for use in our area. It is the standard of practice in our area. So we definitely use the central lockbox. I know real estate agents that put the coded boxes out there because they're $25 at Home Depot or something. I can give you a list of litigation on what that does. So yes, absolutely. Good question, Joe. And Joe, you're always so good about asking rhetorical questions because I know you know. So yeah, we get the authorization to put the lockbox on the property. And then if you're going to use the central lockbox, you can give them a 1-day code to get into the property. I just don't give out contractors codes, but give them a 1-day code but know who you gave it to. And it's only good for that 1 day. So assuming that they're the only ones going to use it. Okay, so here we've got in our lease agreement, I've got my housing provider. Who's the housing provider? Essentially the property manager. Here's up here my definition of terms, right? And then I have my RPO. So I'm going to go through this pretty quick here too. But this is the lease agreement, and again, a commencement date, a beginning date, and then a termination date, and then my rents. What that's going to look like, and I'm looking for key language I need to point out to you. Security deposit, where's that going to go? In our office, it goes to the owner. It's very clear that we don't have it, and not to be used in lieu of last month's rent. So you never want to use the word first and last, because then the tenant assumes that they paid last month's rent and now they don't give you the rent for that last month, when in fact it may have just been a linguistic problem or a semantics problem. But you need to make sure that, and again, remember that the law is clear as to how much of a deposit you can charge, right? So you may not charge more than an equivalent of 2 months rent for an unfurnished rental, an equivalent of 3 months rent for a furnished rental, and you need to look at Civil Code 1950 for the breakdown and all that. Okay, so and then now finally, thank you. Security deposit will not be returned until all the tenants have vacated and the keys returned. Any security deposit returned by check shall be made out to all of the tenants. So if you get one check from the tenant, 5 tenants, then one check goes to 5 tenants, unless all of them agree. And I've done this before where all of them agree, to give separate checks, even though one check came from one tenant. Okay, so I'm looking for the language I wanted to show you about it doesn't have it in there. I thought we had it in there about the amount of money you can collect as a security deposit. Don't collect more than that, folks, and that's why this paragraph up here becomes a challenge, is that you may be exceeding your legal right to collect money. So it may look like an advance rent. They don't want that. Law doesn't want that. Move-in costs, etc. Oh, here we go. So right here, the maximum amount of security deposit, and I've already told you all this, so I'm not going to read it to you again, does not prohibit the payment of advance rent of not less than 6 months. And I had a tenant come to my client was a judge who owned the property, and the tenant came in and said, I'm going to give you, a year's rent up front. And then we see that they have an unlawful detainer a couple doors down on Mango Drive, actually. And we said, well, why weren't you paying the rent? They did an unlawful detainer. They evicted you from the property. And he says, it was the principle of the thing. So folks, I've got to tell you, people do things for the principle of the thing, but they paid this judge an entire year's worth of rent. And so didn't have to worry about the limitations on how much you could charge for deposits. Parking, storage, utilities, who pays for what, condition of the premises, definitely. So we have 2 forms now. It used to be the MEMO, the move in, move out. Now it's either the move in or the move out, 2 separate forms. Maintenance and reporting, again, all these are changes of terms. Neighborhood conditions, same kind of thing. I always tell them, go out there, when do you sleep? Well, from 9 at night till 6 in the morning. Well, then you need to be sitting out in your car at that time to see if there's anything going to keep you from sleeping. Pets, we're going to talk about a pet addendum here in a minute. So no pets are allowed except, unless otherwise authorized, and that's going to be the pet addendum. Remember, a service animal is not a pet. A service animal is an extension of the person. So you may not charge an extra deposit, no pet deposit. You're going to go for that. That's going to be a bad thing. So, and that's again, Civil Code 54. So, smoking of any kind, rules and regulations. What else in here? Again, I do whole classes on just this form, but alterations to the premises, obviously you got to have permission. Entry, we've got some notice of entry forms. Photographs and internet advertising. This is becoming more and more of a problem lately, where I'm having people complaining that that the agent was going through the house taking pictures, and this is not the seller's agent or the owner's agent. This is just somebody going through taking video and putting it up on the internet. And it's like, I don't want my stuff up on the internet, and so it creates a problem. So we have check boxes in the listing for allowing or not allowing that. Possession, etc. Hurrying right along here because I got 10 minutes to do a bunch of stuff. So let me see here. Damage to the premises, insurance. Yeah, you can require the tenant to have insurance. So the owner can require the tenant to have insurance. Minimum numbers right here. And oh, by the way, have yourself as an additional insured, right? Additional insured for injuries. Water beds. Does anybody still have water beds? Water beds, the displacement, the weight of a water bed has the same displacement as a refrigerator, but yet we still make a bunch of fuss about it. So, okay. Ray, can you distinguish if we can handle a pet differently if it is an ESA as an emotional services animal versus a service animal? I've always felt it's very gray, and that's a great, Ray, that's a great legal question. Okay. All right, so moving on, because you know what, I don't know what to tell you. The laws on that change too. So I don't know. I see the pet iguana coming on. I was on a flight the other day flying out of San Diego, and the guy's got a dog inside the little pooch inside the thing. Well, but we're sitting in the aisle that has no place to put your dog under the seat in front, right? Because there's no seat up under front, right? And so the flight attendant was just in a state because, you can't have anything at your feet. And yet it's a service animal. And so guess what? Service animal won. So, and I told the flight attendant, so anyway, the guy had no place to put the service animal. So, it's like, and then of course the flight attendant said, I'll put it up in the luggage. No, you're not. It was great to watch the interaction between these two. Can you require the tenant applicant to have tenant insurance as mandatory? Yeah, the owner can do that, sure. Yeah, and by the way, we'll talk about the application here in a second, but good question, Lena. Tenant estoppel. Listen, I love the tenant estoppel certificate, folks. You need to be getting this. You're going to have to, if the owner decides to sell the property, you're going to have that tenant estoppel certificate. It's referenced in the TOPA, the tenant occupied property addendum. So you need to have that. Let me see what else in here. Just going through here pretty quick. Oh, so here's all my disclosures. Look at this: mold and dampness by default. I already showed you the form. Lead-based paint, we talked about that. Periodic pest control. You see all this, the same stuff we saw in the property management agreement. Death on the property, time of essence, and all that stuff. Okay, so everybody understand that these are in every single lease that you do, whether it's property management or whether it's a leasing agent, in every single lease that you do. Okay, I'm just flying down through here. You could have a guarantor, somebody who is going to guarantee that the tenant makes the rent payment. Then I get into my bed bug disclosure. And then I've got my tenant flood hazard. So CAR has done a great job in adding these as your template. Here's my rent cap and just cause addendum. Just when you thought all that was over, we still have it. Okay, and look at that. That was amended in 12 of 20. So, it's still alive and well. Again, most owners are going to check this box. Let's see what else in here. Fair housing discrimination advisory. I personally think this should be at the front, but up at the top, not elsewhere in the form, kind of as an afterthought. I think it needs to be up at the top, but that's just my thoughts on that. So that's my lease agreement. Let's take a look at my application. Now this has changed, and this just changed in December of this past year. So this is only 3 months old. So some significant changes in here. One of them is that it's an application to lease or rent. And so because it used to be the application, the LRA, lease rental application, and now we've said lease or rent. And by the way, you may not run a tenant's credit report without having written permission to do so. And that's what this form does. Okay, but you do have the ability. We've changed some of the numbers on the screening fee. I'll show you that in a second. Folks, we are going to go a little bit over. I'm going to try to do this fast, but this is important. A separate application for each occupant 18 years of age or older. I'm going to tell you, they don't put it in here, but who's going to occupy the property for more than 14 months or 14 days in a calendar year. That also includes emancipated minors. So if they were military, if they're 17 years of age, they're not the age of consent or the age of majority, we call it, but they could be emancipated. If they're in the military, they're emancipated. They have to get their parents' permission, right? That kind of thing. So be aware that that's a possibility. Let's see, we're not doing the SS on this page, but we are going to do it on the next page. Remember, this information is important in case we have to go tracking the tenant. So here's creditors information, personal references, and then down here, if you're going to authorize us to run credit, right? And this is not a guarantee you're going to get the property, but you sign the document. And then down here, the housing provider fills out this information, how much it's going to be and all that. Here's the screening fee. The numbers have changed. Now we are authorized to charge $52.46 as a screening fee without having to provide an itemization. But again, pay attention to this because these numbers change. Remember, it's tied to the consumer price index. So for the longest time, it was like $32. And this was a huge rewrite of the property management forms by CAR. So, this is a really big deal, folks. So, some of the stuff had to be brought current. Okay. Let's see, credit reports prepared by. So in our office, we use Smart Union to run credit. The tenant pays them directly. We don't want your money. But again, we may be calling past landlords, so we might charge. But here's my CPI, reference to my CPI. And you can go to the website and whoops, darn it, clicked on the wrong button there. All right. So applicant shall provide SS number to the housing provider. I don't really want that in my file. So we really don't like their social security number, but the owner gets the credit report that does contain the social security number. So, we don't necessarily want that in the file because we don't want, Privacy Act issues or anything like that to become a problem. And then there's my my burn form, notice of background investigation. And then again, you must have their signature in order to notice there are two places for the tenant to sign on this, right? So they're going to sign it here under paragraph number 9. And then under screening fee, they're going to sign it again. So you have to have both. Clearly, if you want to run their credit, or charge a screening fee, you have to have their second signature. I frequently see it where they sign once but not the other, and so you don't want to go for that. Okay. All right. Extension of lease. So we're wrapping up another section here. So that was lease listing, and then we have the residential month to month, application to rent, extension of lease. We're going to talk about that really quick. And here it is. So again, I pulled up forms. I mean, you've been here for 2 hours. You've got to understand that it's a complicated process, but this is what you're being paid for. And again, check with your broker, make sure that your broker allows this kind of thing. And I will help you, but not to get in front of your broker. I'll never do that. So this is the extension of the lease, again, signed between the landlord and the tenant. We're gonna have to change that landlord again. They should have gone through all the forms and changed all references, excuse me, to landlord. Here's my qualified California real estate lawyer. I mentioned earlier the QCREA. I've had enough lawsuits where the plaintiff hired a general practitioner who did not become qualified. I think personally, and again, it's not legal advice, and I'm not going to interfere with their knowledge, but I have a great time in court. Extension of the term, rent shall be, security deposit shall be increased by. Remember, there's laws that affect how much you can increase the rent or the security deposit. Make sure that the owner is checking with their attorney. And again, there's my rent cap and just cause addendum. And so that is my extension of lease form. We already went over the RCSD, so I won't have to do that one again. Let's catch up here. Pet addendum. Let me show you the pet addendum and then the pool and the hot tub addendum. Let me see here. This is oh, what did I do? Did I not pull it up? Oh shoot, I didn't pull up the pet addendum or the hot tub addendum. Anyway, trust me, we have forms for that. Key safe lockbox, and again, Joe asked a really good question, and this is kind of important. In the listing agreements is a paragraph that authorizes the broker to install a lockbox. Now, it explains to the owner of the property the ramifications of that. We don't have insurance to cover your stuff, and just us putting a lockbox on there doesn't imply that we're going to get insurance for that. Okay. Again, as Lena said a minute ago, we need the tenant to insure the property and then name us as an additional insured anyway. But this KLA is a separate form, and so I like the KLA and I use it in all of our listing transactions anyway, even though I've already got authorization to put in the lockbox. But here's why. Look at the language in this. This is clearly one paragraph in the listing agreement, but 4 paragraphs in this form. Okay. And then you get the permission separately, and then the tenant signs it if you're going to have a tenant. So whenever we move a tenant into a property, we have them sign this form so that that they understand that we're going to leave the lockbox on there, or we're going to put one on there at a later date or whatever. And so we need to have their authorization to do that. Again, this is a 2013 copyright. We haven't really done anything to it in 10 years, but it's pretty basic form 413 up here. So I would definitely be doing that. And then I've got my cancellation of the lease or rental. People call me all the time and say, well, how do I cancel the lease? And again, if you are a leasing agent, you would not use this form, right? Because you don't do property management. If you were a property manager, then you would probably use this form. Use as a notice of termination of tenancy. Okay, not for use of notice of termination of tenancy, but it is a cancellation of the lease or the rental. And so it goes in through here, who's canceling, much like your cancellation of escrow, cancellation of contract form is going to do. So there you see all that. Again, Civil Code, if you're going to do property management, you need to get familiar with Civil Code 1950. Okay, what else? Only used for reasons below. If it's subject to rent eviction control or whatever, then you have other challenges. Okay, and then last form is my tenant estoppel certificate. I told you we're going to talk about this. We'll talk about it for a couple seconds. We're not going to go deep into it, but I always have the tenants fill this form out at the beginning of the lease. Here's the lease, the whole lease, and nothing but the lease, so help me God. I checked 1A, copy of the lease is attached here too, the date of the lease. I'm going to fill all this part in on the program in zip forms. I'll fill it all in, and then the tenant and who's paying what, and then the tenant will sign it. I'm going to need it if the owner decides to sell the property, because it's going to be asked for in the TOPA form, right? So if you're selling a property with a tenant in it, and remember that form now says that the owner will make reasonable attempts to get rid of the tenant, good faith efforts to get rid of the tenant. But if they're unable to do so, the only recourse that the buyer has is going to either be to take the tenant or to cancel the transaction. Well, if they take the tenant, then we need to have some representation from the tenant as to who does what. I've had it happen where the tenant's deposit was $1,200. Later on the tenant tried to get the deposit, $12,000 back from the buyer who now owned the property. So you have some challenges with that. So again, I'm going to have them sign this document down here, and I'm going to have the landlord or the property manager sign it as well. But that's my TEC, and I like that form. It's a great form. I rarely ever see it utilized. I had an attorney on one of my webinar last week, and he made the comment that like the SPQ, he's like, we never see it in any of our lawsuits. Is it a lawsuit because the SPQ wasn't utilized? And I think the answer is probably going to be yes in a lot of those cases. So some of these things, SPQ, of course, but SPQA, why didn't you use it? And I had an attorney call me and say, hey, my broker's being sued, and so before you say anything, I don't have an SPQA. And I'm like, well, I don't know what to tell you. Anyway, they settled that case. They didn't want to fight that one. So same thing with the tenant estoppel certificate. If you don't know what it is, you need to do your owner a favor and make sure it gets filled out by the tenant, signed by the tenant, and you make the representations in here. It's a lot easier for you to fill it out right online and then have the tenant sign it. Okay, so that is it for the forms. Now, what else did I want to tell you? So we did the RCSD, we did the KLA, cancellation of lease or rent, tenant estoppel certificate. So my favorite is always to tell everybody, when you define your duty, you limit your liability. And so this is why in these listing part agreements, the property management agreement, the lease listing agreement, I'm defining what my duty is. It's the people that try to do these things without having a writing that says this is what I'm going to do, this is what I'm responsible for. They're the ones that are really throwing caution to the wind, and I would say, not good. And as I said in the beginning of our presentation today, if you think that, hey, I didn't charge for the services, or I didn't get paid for it, or I reduced my commission, those are not going to be defenses to the action that's going to be brought against you. So I think you need to make sure all of this is in writing, and I think you need to explain it to the client. We can see based on today that this is a fairly complicated process. So if I go back over here and I take you to my, says I'm going to go away here. Oh, shoot, it's going to sign me out. Oh, darn it. Anyway, I have a lot of forms in there, right? So, but I wanted to be clear with everybody that there's a lot to this. And as I said earlier, if you do property, it's kind of like a trust attorney. If they do trust, they probably pretty much do only trusts, right? It's a living, let me tell you. And same thing with property management. If you're going to do property management, it's a living. And so it's going to be a lot of work. It's not insurmountable. But again, check with your broker, make sure your broker allows you to do property management, and then make sure you do property management the right way. And like I said, I've got quite a few property management clients who consult with me on different contract related issues, things like that, not giving them legal advice, but more practitioner's advice. So, and again, I'm happy to help you in any way that I can. TEC is not an addendum. TEC form in the beginning of said attached lease. It's the tenant estoppel certificate. It is a legal term, Virginia. I think that's what you're asking. It is going to be in every lease that we do. Hopefully I'm answering your question. If not, please let me know. Okay. Let's see. SDR posts the webinars. They're trying. I mean, listen, they are the hardest working group I know, and they try to post all the webinars up on the YouTube website. This is the short link to get to the YouTube website. So case is important. It's bit.ly/YouTube SDR. YTSDR are all capitalized intentionally, and that should get you there. You can always call me. I am always happy to help. You can send an email to education@SDAR. There are classes that you would like to see offered. I don't work for SDAR. I do quite a few of their classes, but again, if you want me to teach something, let me know, and then I'll just let them know, and then we'll just go ahead and roll it from there. So I do have a newsletter that goes out once a week. I'm sorry, Virginia, applicant criteria, where, when is that established between the RPO and the housing provider? Applicant criteria. The lease rental application, clearly before you ever sign have a lease agreement signed, if that's your question. And we want all the details. It's kind of like, you hand me the file and say, I want to get paid tomorrow, but I know very clearly that if it closes, I'm going to spend the next 6 months tracking people down, income, FICA, et cetera. Yeah, again, I like third parties doing that. SDAR has, Virginia's question is a good one. Where do we get the information on income, the FICO, and all that? So if I take us back over here really quick to my lease application. I've got so many windows open. Here we go. Okay, so if I take us back over here, then this is going to be where this is my my LRA form, again revised recently, and this is going to be where I'm going to get all that information from them. Okay, and again, separate one for each occupant above the age of consent. Who's going to occupy the property for more than 14 days? What is their history? I'm calling the past landlord, and I'm probably not going to call the most recent landlord. I'm probably going to call the one before that, because the most recent landlord has a vested interest in getting rid of a bad tenant. So, but the previous one, that is like, hey, no, I'd never rent to them again. Remember, you can't say, were they a good tenant, but you can say, would you rent to them again? Because one is qualitative and one is not. So were they a good tenant? I don't want to open people up to getting sued for that. So I just say, would you rent to them again? Well, no, I would never rent to them again. Okay, well, fine. That's all I need to know. Okay. Employment and income history. Is this, I think, Virginia, this is what you're talking about. Credit information, personal references, relatives. I think that's what you're talking about. It all comes in on my LRA before we go another step. By the way, on that note, and your question reminded me, good question. Your question reminded me, I do not get a copy of the driver's license when I'm getting the owner's approval of whether or not to take the tenant. And part of that, again, is going to be my fair housing issues. So, the driver's license can frequently say a lot about the individual, that, the picture, et cetera, that I don't think is something that should be used in a decision to rent to somebody. So I'm not going to send them a copy of the driver's license ahead of time. And if they ask for it, then I'm going to say that might fall into that buyer interest letter. Okay, so that's that form. And then I do have a newsletter. It goes out once a week. You all know, Friday night, about midnight, it goes out, and it's got check boxes for, logging into the webinars that I'm doing in the following week. That way you skip the message that says it's sold out. And listen, I want you in there. But I don't put people in the newsletter unless you ask. So send me an email. I'm more than happy to do that. There's my email address for those of you who wanted copies of anything that I was doing today. It always interests me. I have 50 people on the webinar, and then 3 people actually ask me for things. And by the way, I had tremendous respect for the other 47. I might have talked them out of doing it, but at the same time, I want to help you. I want you to be okay. As I said in the very beginning, if you look good, you make me look good. So I want you to look good. We're raising the bar for the real estate community. We're professional people, not experts. We're professionals, and so I want you to get what you deserve. And so I'm here to help in any way that I can. So if you don't have any other questions, anybody have any questions, I'm happy to answer those. Otherwise, send me an email. I'm happy to handle it off site. Give me a little bit of time to respond, by the way. I've got another webinar coming up right after this. Starts at 2 o'clock on creating the zip forms template. So I'm probably going to show you how to create a property management template, since we talked about that this morning, but I'm also going to show you how to create the buy sell template, but I'm also going to show you how to do your signature, because the DRE says that your signature in zip forms and in the MLS has to be first contact compliant. And so that'll be the webinar we're going to do in about an hour and 3/4. So as we say from my hometown of Del Mar, I look forward to seeing you around the track. Thank you, everybody. Appreciate you being here today, and I appreciate the value of your time. Take care for now. Bye-bye.